At a glance tab, this is where all the analytics come into play. And I'm going to show you where the raw data exists on this and why you'd want to uncover it. But at least at a high level, understand how many active cases the judge has, how that compares to other judges in the county. For the state, you guys are special in California. You guys have huge jurisdictions. So like you'll see, right? Judge Heiberger with 770 cases kind of falls to the just to the right of the middle in terms of other judges in the state, but in LA County is like square in the middle. So keep that in mind. Always use this as a comparison purpose. Now, I will tell you, right, what I'm looking for as a practitioner for motion grant rate, I want my judge to be somewhere in the 50 to 60 percentage, right? The reason why, if if I have a motion to compel, I expect my judge to grant those motions to compel, right? Those are really basic motions. Whereas if it's a dismissal motion, if it's any kind of dispositive motion in front of the judge, I would hope that they're going to be a little bit more, let's call it fair, right? It's not an automatic grant, if you will. So I use this just as a rule of thumb. Is it in between 50 and 60%? Great. Then I'm not going to worry about it. I can take a look at individual motions here in a second. The one other practice pointer here where it says verdict, plaintiff versus the defendant. Okay. Do not freak out about this ever. And here's what I mean. When we see here that it says he's going to rule, let's just round up and call it 2/3 of the time with respect to the defendant. This is with respect to bench trials, not jury trials. If there's a jury verdict in front of Judge Heiberger, we are going to add that to the verdict portion of Trellis. We're not going to assign that result to the judge, right? We're going to say that was part of the jury itself. It wasn't a Judge Heiberger decision. This is only with bench trials. And to give this context, right? That's why we have the case practice area breakdown. Here, I can understand, right? For 30, let's just call it a little bit more than a third of his cases are torts cases. And we can break that down further. Mass torts are 50% of that. Those cases are not bench trials. I'm willing to bet, right? So if I have a case that falls into one of these categories, I'm not really worried about his statistics for the verdicts, right? Square that with something that probably is a bench trial. Like, so you could do creditor, for example, but creditor makes up 4% of his caseload. So maybe I care about it, maybe I don't. Where this is actually being put in place, anecdotally, I will have lawyers where if they draw Judge Heiberger and let's pretend, right, in insurance or a creditor case is on their docket, they'll say, this judge doesn't have a ton of experience in this area of law. I'm going to take my time to make sure I'm educating the judge on the law in whatever motion I'm filing, right? So their motion practice will change. They will definitely take more time outlining their stance. Whereas if it's a torts case and it's a mass torts case at that, Judge Heiberger knows the law.